Do we have the Spanish interpreter?
Yes, good morning, Your Honor. This is Jeff Adams, Spanish interpreter, registered with AOC certified number 4530, asking for permission to keep my camera off due to bandwidth issues this morning, Your Honor.
That's fine. All right.
Thank you.
With that, this matter is on for a review hearing regarding the Guardian Item report. Have the parties received a copy of the report filed on April 9?
Las partes han recibido una copia del reporte emitido para que constara en acta el 9 de abril.
We have, Your Honor.
Así es, Su Señoría.
So with that, counsel, anything that you would like to present at this time?
And Judge, we're on for a review. Who do you want to hear from first?
Go ahead, Mr. Sandy.
And we'll start with the alcohol issues. Largely, I think a lot of what is in Mr. Billy Garcia's pleadings is information that was not presented at the last hearing in March. A lot of that relates to the alcohol new allegation, as well as these visitations that have commenced over the last month. Surprised by the alcohol allegation against my client, given the information that was provided to the court. Certainly our position is that was done in retaliatory nature and frankly bad faith. Here a month ago, there was no allegations against my client related to that. That, in addition to the text communications between the parties, shows that Mr. is the one that continues to suffer from those issues. And my client who continually encourages him to cease in his alcohol consumption as well as smoking, and ties that directly to the well-being of Gianna. In response, he talks about hitting his tire against the sidewalk, talks about going out for several beers with his friends after work, and directly implies that he continues to drive while impaired. We've also given you information from my client that says she rarely, if ever, drinks. Also have concern about the allegations raised in the pleadings provided by Mr. Garcia related to these visits. Again, what Mr. Garcia claims is directly refuted by the information via text message and communication between the parties. The client's gone to great lengths to effectuate those visits and make accommodations, including taking risks at work with her schedule. The client went so far as to pay the initial $100 through reconnecting families to commence those visits last month. Mr. Garcia spends ample time in his pleadings pointing the finger at my client that she's been resistant to those visits, but again, the text messages show something completely different. He goes so far as to say that the visits were cut short by my client and her family, when the information shows that he was the one that was intentionally cutting these visits short. I'm not going to go into great detail as to what the texts say. They largely speak for themselves. It seems to be a classic example of preparing for litigation and the facts change significantly from the pleadings from what is actually happening in reality. That's a concern moving forward for people to be able to effectively co-parent. Had significant issues acquiring Mr. Garcia's work schedule. Counsel did forward me information on that via email late last week, so we do believe we know where he's working. Other information provided shows he's currently working 3 jobs with no specific work schedule that we can bank on between the 3. When it comes to some of those issues, again, these parties need to communicate. We're asking that Mr. Garcia provide his work schedule well in advance. My client's work schedule is consistent. She continues to be employed at Peace Health. The suggestion seems to be that she jeopardize her job and leave so that we can accommodate the visits of Mr. Garcia. And in our opinion, that's inappropriate. Our suggestion is he provides that work schedule to my client either on a weekly or monthly basis. Other consideration is this child's daycare schedule. Currently, if she's dropped off at 9 o'clock, she cannot be dropped off between the hours of 9 and 2 p.m. So we'll need to accommodate that to some extent as well. As it pertains to the GAL recommendation, we're largely in agreement with that schedule, with a few practical changes to accommodate my client's work schedule and the child's daycare schedule. We're suggesting 2 weekly visits on Mondays and Fridays from 10 a.m. until 2 p.m. each day, and every other Saturday from 10 a.m. to 4 p.m. To give my client the ability to have full weekends with the child while she's off from work. And also give the father a significant jump in time, which is consistent with the GAL recommendation. My prior arguments last month, I stated that these parties needed time to build trust. We're not there yet, but our proposed schedule will give them again another building block, enabling hopefully to get to that step. Communication continues to be an issue, and I think that's evidenced through the text communications. And the reality is this is going to take time to get these parties to a comfortable position. In the meantime, we have an exceptionally young child who, again, needs time to familiarize herself and get comfortable with that. Standard provisions about safety restraints for vehicle transportation should be included. The existing provisions are related to death, alcohol consumption, and smoking around the child. We believe our proposed parenting plan best suits the interests of this very young child, and are asking the court to adopt our proposal as such.
Yes, Your Honor. I think today we should just focus on the positives because I don't believe that it's going to facilitate a good co-parenting relationship if we are finger pointing. Some positives that both parties have are they both love Gianna and both parents want either parent in Gianna's life. Some qualities that father appreciates about mother is that she's knowledgeable in infant care and she has passed along that information on to father. And also he appreciates that her priority is keeping Gianna safe. Some positives about father is that he's a fast learner and willing to learn. And he also wants to be involved in Gianna's life. And then the text messages that were included in mother's declaration about father's alcohol were also shown to Ms. Schaefer, and it was shown before she made her report. These text messages were made before Gianna was born. Since November, father has completely stopped drinking and has not smoked. And I have filed the hair follicle test, which was taken in February to show that father passed that test. And then just to clarify some other statements made in mother's declaration, father doesn't dispute that mother's parents were offering him parenting time. The only point being made at the entry of orders hearing was that father's work schedule was limited his availability to 2 to 4 p.m. for Fridays. And then anything else referencing scheduling issues in father's declaration was mainly in regards to father's work schedule and his limited availability during that time. And additionally, father does not dispute that mother initiated contact with Reconnecting Families. He appreciates that mother set up these sessions, and he's willing to pay her back that $100 fee that she initially had to take on. And as for the alcohol references of mother in the court investigator's report, he wants to make it clear that he does not believe that mother needs an evaluation or treatment for alcohol. He only provided that information because he thought he needed to, for the court investigator to have that information. He had no other intentions when sharing that information with Ms. Schaefer. Father is encouraged by the recommendations in the court investigator report. He believes having access to medical records will help lessen any communication that he needs to ask mother about Gianna's health and or care recommendations. He wants to lessen that burden on mother since that was a concern in the report. And additionally, he does have family members who can help him give advice on how to care for Gianna as well. So he has additional support rather than just having it solely be on mother to tell him how to take care of their daughter. He believes using our family wizard would be a great way for both parties to send information regarding medical appointments to each other, along with any other important information about Gianna as well. Father's current work schedule is Tuesday to Saturday from 10:30 a.m. to 9:30 p.m. Father's proposed parenting time, he agrees with mother's request that he have parenting time on Mondays from 10 a.m. to 2 p.m. But the other proposed dates and times provided by mother conflicts with his work schedule. Father is proposing having either parenting time on Wednesdays or Thursdays from 7 a.m. to 10 a.m. And he understands that this is a bit of a early time. So he's willing to do all of the transportation of going to mother's house to pick up Gianna and dropping her back off either at her home or at daycare. And then for the 5-hour visit recommended by Ms. Schaefer, father can do Sundays from 12 to 5 p.m. Father would like to have every Sunday. This will allow mother to have the full day on Friday and Saturday for her weekend time. Father would like the Sundays to be in the afternoon so that his family can meet Gianna since they have not yet done so. And father has car insurance and a license, so he can abide by that safety restraints that Mr. Zandi just mentioned. Father's work schedule did have some differing times in the past, but now he completely has Sundays and Mondays off and will have that for the foreseeable future. Then the only other recommendation that has not been addressed yet is Ms. Schaefer's recommendation is having overnight parenting time once Gianna is able to communicate her wants and needs. Since this can be left up to interpretation, we are requesting that there be a review hearing once Gianna turns 1, which is in August, to see if Gianna is now able to communicate her wants and needs or increase the parenting time schedule to something that does not include overnight time if she's not able to communicate those needs. And that's all I have.
Es todo lo que tengo.
Ms. Schaefer?
Yes, Your Honor. I
Sí,
would
sí,
just
señoría.
I would just like to clarify that it was during my investigation and talking to Dad about the allegations of drinking,
Wait,
that he also responded that Mom was also drinking during those times while they were dating. And then I had just followed up with Mom regarding those statements. And it was not meant to be intended that Mom had a drinking problem, was not my implication. That's my clarification.
Any response?
I think we should,
¿Alguna respuesta?
my suggestion is we simply reserve on the overnights. This child's not going to be able to communicate her wants and needs at the age of 1. This case should frankly resolve well before then. Although it's not ideal to have an exchange or pick up the child at 7 a.m., given the work schedule, that 7 to 10 a.m. might be the best we can do. If that's 1 day a week, and have him take her to daycare, but that would have to be at 9 a.m. pursuant
Pero
to.
eso.
We have said if the court is inclined to order Sunday visits, that those be a little bit earlier in the day. We're suggesting from 10 to 3. Still that those be on an alternate basis.
Y
So I've reviewed the files and record. It will continue that there will be no use of alcohol, marijuana, or any other non-prescribed drugs 8 hours before or during time with the child. The court still has some concerns about potential use of especially alcohol. If he's not drinking, then that shouldn't be an issue. The father will provide his work schedule in advance on a monthly basis. The father will have the child on Monday from 10 a.m. to 2 p.m. and Thursday, 7 a.m. to, is it 9 a.m.?
9 a.m.
And he will need to take the child to daycare on that day. And then I will go ahead and order the Sunday visit, but from 10 a.m. to 3 p.m. That will be on alternating weekends, so the mother can have full weekends with the child. Any person driving the child must be fully licensed and insured and use an age-appropriate safety restraint or seat when driving with the child. It's really difficult to know about when overnights will be most appropriate. So for now, I do want to reserve on any overnights. I will require the father to go ahead and pay back the $100 fees. In regard to decision-making, at least at this time, it will remain with Mom. As the father gets to know the child, then that's something that can change in the future. The father should be given notice of any medical or therapy appointments so that he can know and learn about what's going on with the child. I think it would be appropriate to use a parenting app such as Our Family Wizard. So my question is, at this time, is Ms. Schaefer was really just a quick turnaround type report? I can appoint a longer term guardian ad litem if you think that's needed. Mr. Zandy?
I don't think it's
Licenciada Zandy.
necessary at this point. I'd rather get these two into mediation and see if we can resolve the case between us. And if we have to come back, we can.
Counsel?
That's fine.
Licenciada. A mí me parece bien también.
That's fine with me.
Está bien conmigo.
Is there anything else that I need to address?
And who do you want to prepare that order?
¿Y quién quiere que aliste esa orden?
I think Mr. Zandy, go ahead.
Okay. That's all. Thank you.
Es todo. Gracias.
Thank you to the interpreter. You are excused.
Gracias al intérprete, ya puede retirarse. It's been a pleasure this morning, Your Honor. Counsel and Your Honor made it very easy for this interpreter. Have a good day. Thank you.
Thank you, you too.
Thank you, Your
Good
Honor.
morning, Your Honor. Amanda Holder here for Bradley Randall.
And for the record, Christy Gardner is present in the courtroom. So there are two things that are on the docket. The first one is a presentation of order. So I did not see any objections. Did you receive a copy of the proposed order, ma'am?
No.
Okay, Ms. Holder?
Your Honor, I'm currently working with Ms. Gardner to get something together. I still have yet to be able to talk to the girls' counselor here. Ms. Gardner and I have had a productive conversation regarding what would be in the girls' best interest, and that would work well with my client and with her schedule. Ms. Gardner has been traveling, I believe. The girls either had softball or volleyball. So what I would ask at this time is that We don't set a review hearing on this because I'm confident that Ms. Gardner and I can come up with some kind of agreement, and then we can get those orders sent over to you, and we can do that off docket. And if I need to, I can always renote a hearing.
Does that work for you?
Yes.
Okay. All right. So with that, I will go ahead and just strike the matters from today's docket since we're not doing anything, and then it can be renoted, put back on the docket if something needs to occur. Okay.
Yes, Your Honor.
Thank you, Your
Noel
Honor.
McLean appearing
Thank
on
you.
behalf of the respondent, Tristan Peterson.
And Amy Trumbull, the guardian ad litem.
Levi Bondurant is also present, Your Honor.
Okay, please take your hat off. Thank you. All right. So there are two matters. First, and we do have Ms. Turnbull present. The first matter is to review hearing for the final guardian ad litem report. And the report was filed, but I didn't put a date. Is it filed? I'm not seeing it.
I mailed it for filing. It may not be
That's
in an
right.
Odyssey yet, but I did email you a copy.
Okay.
And I've received a copy.
Fine. Can you hold on just 1 second? I forgot to do something. All right, sir, did you get a copy?
Amy, was that sent by email?
Yes, it was.
Then I would have gotten it. I did not actually. I'm checking my emails now. Yeah, I see something here for it.
Okay. All right. All right. So at this point, I don't have any motions that apply particularly to it. And it's the report I know is coming or is already in the process of being filed. I did receive a copy of the report. Anything further on that matter at this time?
Not on the GAL review.
Okay. Mr. Bondurant, anything?
No, Your Honor.
Okay. All right. So the next issue has to relate with the discovery, and my understanding is no discovery was received, correct?
That's correct.
All right.
Even as of today, I've not received anything.
Okay. Mr. Bondurant, you did not send any of the discovery?
Your Honor, to be completely honest, like I said, I mentioned this. I'm not an attorney. I was not sure if that was something that was needed to be ordered by the court. I just the questions that were asked, and that some of them I was kind of like, does she just get to ask anything and everything, and I have to give that information out there without having been enforced by the courts? And I let her know that over the phone too. So there had been no order by a judge to do so, and I told her if there was, then I would send that information immediately.
Well, the bottom line is that it essentially was ordered in the sense of that I ordered you to provide the discovery, and that if you didn't, then I would be striking your pleadings and finding a default, essentially saying you didn't respond. So that's where
Was that
at this point.
sorry? Was that something that was mentioned in the earlier court date that I may have missed, Your Honor? Because I don't recall that information being relayed over to me. I mean, I could be wrong.
Your Honor, we filed with the court verification, a certificate of service that was filed on April 12th that we forwarded a copy of both our proposed order on default and then as it related to the actual order to compel, that has also been forwarded to Mr. Bondurant on March 28th. A conformed copy of that.
Yeah. So on March 26th, there was a hearing. I haven't dug into it to see whether you were or not. I don't think you were, is my recollection, but I still made my order to compel, which required you to respond with the discovery. Now, whether there are possible objections to any of the questions, that I can't tell you. That's giving legal advice. Unless I see objections and the basis for it, and then I rule on it. But at this point, I don't have that. So with that, I don't know what else to do other than to grant the relief because Ms. McLean's done everything that she's required to do.
Your Honor.
Okay.
Again, I don't understand a lot of the legal terms. I'm getting these emails and I don't even understand them, what I'm getting. You know, and again, from the financial side of it, that I'm being told that I need to, or I'm going to be asked to spend money for an attorney, and if I had one, I would have one for myself to be able to translate these legal documentation. So, I mean, it's a lot easier when it's over a court hearing and a judge can actually put it into a language that I can understand. Ms. McLean has made it a point to make it very difficult with me directly, and in terms of explaining what I need to do. I did tell her that I felt uncomfortable on some of the questions, that some of them were redundant. But again, whatever you order, Your Honor, I have to respect, obviously.
So, Ms.
Obviously,
further?
go ahead. I would just ask that the court grant the relief requested. I have not made this difficult for Mr. Bondurant. I've followed the rules. When he had contacted me I contacted him during our CR 26I, and he told me he wasn't going to comply unless there was a court order, which I provided as far as information in the initial declaration on the motion to compel. I told him I could not give him legal advice because I was not his attorney. He has been advised to contact Legal Aid or Northwest Justice Project for additional assistance if he couldn't afford an attorney. So that's not my obligation to give him legal advice. We've provided him with notice of all of the information and documentation as we moved along. I made supplemental requests for discovery that the court had already determined. And I think it speaks volumes, the fact that he's not even complied with the court order of services relative to correcting his parental deficiencies. And that's outlined in Ms. Turnbull's guardian ad litem report. So my perception is that he's simply throwing his hands up and trying to place the blame elsewhere rather than taking responsibility. So we do believe that it is appropriate to enter the order of default that I've provided to the court. I would note that there does need to be one change made to that order. And that's at paragraph 3B, because I did not anticipate
the claim. I don't seem to, let me see. I don't believe I have your order here. I do have it. It was attached to something else that was marked.
Okay.
Let me get to it here.
So it's entitled Order of Default Rate Motion to Compel.
It's attached as a group together as a bench copy. So let me get to it.
Okay.
So in regard to the files and record, and based on the files and record, the court grants the motion to compel and the request for relief, including, well, the compel is already done, and the request of relief that was made if Mr. Bondurant did not file or provide the appropriate discovery. Mr. Bondurant, Ms. McLean is not your attorney. It's not up to her to explain. She gave you the places that could have been of assistance to you, and so with that, I am going to sign off on the order of default regarding the motion to compel.
So at paragraph 3B, the last sentence, I have Levi Bondurant failed to appear in court on 4/16. If you would strike the words failed to and add ED to appear, so it reads Levi Bondurant appeared in court on 4/16/24. I think that's the only change that needs to be made.
All right, so it should read the petitioner Levi Bondurant has appeared.
Your Honor, would you explain what the motion to compel or by default what that is, please, if you wouldn't mind?
I also cannot provide you legal advice, but basically what it means is that you're no longer, it's essentially saying that you didn't respond, that you haven't done what you were supposed to do. But to get a full and complete answer to that question, you need to seek out an attorney and talk to somebody.
Thank you, Your Honor.
All right, I've signed the order.
Thank you. We will provide a conformed copy to Mr. Bondurant and to Ms. Turnbull once it hits Odyssey.
Okay.
Thank
That's it for today.
Thank you.
Thank you.
All right, so Ms. Bliss, did you receive a copy of the declaration of Ms. Joplin?
I did receive some pleadings from her yesterday and this past Thursday. I've unfortunately had no opportunity to review them with my client, nor obviously prepare any sort of reply declaration, which I, from my brief review, know is probably going to be necessary. So at this point, I'll defer to the court as to how we proceed. I would just note that we were here on March 26th. Ms. Joplin did ask for a continuance at that point to obtain counsel was her representation. We've just received these pleadings within the last day or two. If the court is going to consider her responsive materials, I will be asking for a continuance. Alternatively, I'll ask that we proceed without any consideration of her pleadings and we move forward with my requests.
So, ma'am, there are some very specific rules that talk about deadlines of when things need to occur. I just happened to see this on my desk this morning because it was not timely filed. So can you tell me what happened of why it wasn't?
When I first did it, it got sent back to me and I had to redo it all. And I was just I just didn't get it back to you in time. I was trying to get it printed off and it wasn't, the timing just didn't work for me on that. And I didn't mean to do the second part. When it got sent back to me, I had to redo it all and I didn't.
Okay. So Ms. Bliss, hearing that, I'm probably inclined to go ahead and give her an opportunity because it sounds like she tried, and understanding that she's pro se and understanding that that can complicate things. What I'll go ahead and do is go ahead and put the restraining order will stay in effect at this point until I have something that I have an opportunity to really read. So I haven't even really read it. I haven't, not when I get it the day of, doesn't work. Okay, I know you did it sometime yesterday, but it didn't get to me until this morning. So the restraining order will stay in place. Problem is that the next I'll go ahead and put it on May 7th. It'll get set over to May 7th. But what we have are what are called local rules, and there are the rules in there that govern the dates. Okay, so they're on our Superior Court website. You need, if you're going to not be represented by an attorney, you need to know what those timeframes are. I'm giving you a little room here, but you need to understand that. Okay.
All right. Is there any way I can just see my kid for a minute at all? Just like a little.
Ms. Bliss?
I obviously haven't had the opportunity to speak to my client about that. I don't recall if the current restraining order has any exceptions for telephonic or video conferencing visits. I'm imagining, I can speak with my client, but I'm imagining that could be agreeable pending the next hearing.
So I'm not going to rule on anything at the moment because, again, I don't have it really properly before me today. So what I would suggest is just contact Ms. Bliss and talk to her about it. She needs to be able to talk to her attorney, sorry, Ms. Bliss, her client, and see if you can get something worked out. Okay.
Okay.
So, but otherwise, I'm going to set this over to May 7th. Ms. Bliss, if you want to go ahead and get me the order extending the restraining order to May 7th, then I'll sign off on that. So the restraining order will be in place until that date. But again, be familiar with those rules. Okay.
Thank you, Judge.
Thank you. Are you Thomas McBride?
Yes. Yes, I am.
Sorry. Yeah, McBride. They have it
Thomas
written
McBride.
strange in here. Okay. At this point, Mr. Sandy, have you received any response?
I have not.
I've not received any response or seen any response to the request.
The reason why is I've just recently spent a week in a mental hospital and I've been diagnosed with bipolar 2 and I'm going for full disability. A lot of this is really hard for me to deal with because my emotions get built up and I haven't, like I said, just trying to get a lawyer lined up has been very stressful for me. Everybody I call is like, $300 some odd dollars. And, I don't have that kind of money because my wife has taken away access to all of the money. Like she took it away like months and months and months ago. So I don't know how I'm even supposed to afford anything. She's changed the bank account number.
I can't help you with
that.
Yeah,
I know. So right now I have no response because of that, but I would like to know that I'm going for full disability and that's something I can tell you. This is rough for me. I have they said absolutely disability. So I don't know if you can extend it, not on this order. But I just don't have a response other than, I'm sorry. I just don't have one.
Mr. Sandy?
We're here today, Judge, on my client's motion for an ongoing restraining order, protective order. The facts of this case largely speak for themselves. We provided you information via text communications, as well as my client's statements, as well as third-party statements to kind of show what's going on right now. My client has a legitimate fear and concern. I'm glad and certainly Mr. McBride the best in his mental health treatments, but that takes time. I think as everybody acknowledges and is aware. So we are asking that you extend the restraining order based on the information in front of you. Given the fact we did not receive any kind of responsive materials or declaration from Mr. McBride, I think that's appropriate. And ultimately, we've got concern not only for my client, but these 3 kids as well. Now, this is a 20-year marriage. This is one where they have 3 beautiful children born as issue. Seamus, who's 12, Caitlin, who's 8, and Monty, who is 3. We want to progress in this. This is a case where an order of default has already been entered. That was entered some time ago. We are aware that Mr. McBride did seek inpatient treatment. And again, I think that's certainly positive. My concern is the fact that he voluntarily left after a week, as opposed to the 30-day stay that was recommended by providers. So given his conduct prior to going in and since being released, we do believe that my client's safety has certainly been compromised. And I think the information we provided in those texts verifies and confirms that. So basically, I don't think there is any kind of justifiable reason to extend this. We do want, continue this case. We do believe that extending the restraining order as requested by my client is appropriate. And that's what we ask you to do today.
Do I have a chance to respond to that? I'm not.
Well, the problem, Mr. McBride, is that you didn't respond in writing. I don't have anything in writing, and that's what's required. Sir, listen. Nothing was responded to in writing.
Okay.
And so that's the problem is and like the last case where everything had been done, this case, it was not.
I'm not against the restraining order. I'm completely fine with that. Emily is very triggering for me right now. And I think I'm very triggering for her too. So I'm with that. It's just the kids. She said to my mother and said to me that she was going to drop anything that had to do with the kids on this today. So she's guaranteed to told my mom that. And so I thought we were coming in with that. And, also, I was not recommended for a 30-day stay. I stayed as long as I could, and they said, you're fine, and you're going home.
I can't just listen to you. It has to be in writing.
So if I get writing from my psychiatrist or something, is there a way I can do a continuance of this for the kids part of it? I'm okay with I'm asking for just a continuance so I can get a lawyer to talk about the restraining parts of the restraint part of the restraining order that is to do with my kids. Is there any way that I could?
So here's what I'm going to do today.
Thank you.
You've had since the time this was filed and served sufficient time to get something in writing. That didn't happen. So what I'm going to do today is grant the request because under the rules, that's what I'm looking at. In regard to your request for the continuance, if the court finds that you've had sufficient time to do these things and it wasn't done. So that doesn't stop you from going and getting an attorney and following up with something. Or looking to Northwest Justice Project or California Legal Aid.
Okay.
Those are options that you can look at. But as far as what is being requested by Mr. Zandy's client today, I am going to go ahead and sign the order.
So that's including the kids. It's just re-signing the same thing with the, even though she's that's fine. We can do that. That's not a problem. Can I challenge this if I do get a lawyer and come back?
You need to talk to that attorney and find out what you can and can't do.
Legal advice. Got it. Thank you.
All right. Do you have an order?
I know, Judge, because we didn't know what to anticipate today at all. What I can do is have one come over ex parte, which basically just confirms what we've already got in place. Puts everybody on the same footing, and I think going forward, it's there. Happy.
Can you just show that he appeared in that order?
Yes.
And just put a cover sheet on it?
Yes.
All right.
I will do that.
All right. That's it for today.
Thank you. Thank you, Your Honor.
That matter's ready, and I have a couple of preliminary issues I want to address.
Go ahead.
Thank you. For the record, I'm Chelsea Baldwin, and I represent Stephen Klopp. There was a declaration of Lacey Klopp that was filed, and it contains a significant amount of hearsay or statements for which there's just simply no foundation, and I'd like to go through those with the court and have the court make some rulings on those.
Hold on just a second. We're talking about the one that was filed on April 10?
I believe so. The first paragraph starts, I've submitted the required paperwork.
Okay. Yeah, that's what I'm looking at.
Okay, very good. So page 1, the second paragraph, at lines 21 and 22, there's a claim that the child's bedwetting in my client's home. There's just simply no foundation for that statement. She's not in my client's home, doesn't make any statements that she is.
Ms. Winkles?
Yes, my client states that she was informed that by Mr., and I believe there's text messages that support that.
It's not anywhere in this declaration.
I believe it was previously filed with the court or is in the medical. It may actually be in the medical statements. I believe both parents took the child to the doctor because of that issue. But I'll defer to your honor.
Okay. At this point, I'll strike it. I without knowing exactly where it's. You know, and ultimately, I will tell you when I read this, I will go through this, but a lot of this I took as hearsay as indicated. But let's go ahead.
So same page, just down on paragraph 3, the statement that the child's teacher is good friends. Again, no foundation for this statement, no evidence that supports it.
Ms. Winkles?
Yes, Your Honor. If you'll notice, the child's the teacher's supervisor is a family relation, has a family relationship with the stepmother, or I believe the father's girlfriend, is I'm calling her stepmother in this case, the supervisor of that person. And my client believes and alleges that due to that relationship with the supervisor directly to the stepmother, that they are friends. And considering the district's policy, it also makes sense. It's not hearsay because there's no out of court statement that my client's relying on. That's not what it is. It's an allegation from my client.
So the statements, it's not hearsay is an allegation. There's no foundation. And it's sort of like, hey, maybe these people are related because they have the same last names. That doesn't make the underlying teacher a friend. And there's no statement of foundation otherwise.
I'm not going to strike it. I'll take it for the weight that it has, which I can only include as an assumption because I don't see any foundation.
At page 4, at paragraph 17, and it's actually line 17 as well. So again, no foundation for the statement that respondent has changed the dates on the 911 calls. Doesn't provide any foundation for this. We're happy to file the CAD logs. There wasn't time to do that here, but again, no foundation.
We did file the CAD logs and sent it to everybody involved, including the court. So we received the entire CAD report and filed it with the court and also gave it to Ms. Baldwin. So those dates are incorrect. The CAD report should be with, bear with me. May have made this too big. Your Honor, and I can check and see if it was actually scanned into Odyssey, but it was filed on, I believe it was filed on Friday.
April 12th, it's filed. So I'm sorry, Ms. Baldwin, anything else?
No, nothing, no further argument on that piece.
Okay. Ms. Winkles, anything further on that?
No, Your Honor.
Let's see, get back to where this was.
Oh, I have further evidentiary objections though, when you're ready.
So the issue as far as the respondent has changed the dates on the 911 calls. Let's just address that line. Ms. Baldwin, can you address that particular one?
Yeah, my client didn't. So we're just saying that there wasn't foundation. At the time she wrote this statement, there wasn't the access to the CAD logs. She doesn't indicate that she's looked at the, I will have CAD reports at the hearing. So she's not saying I've looked at them and I verified that I have them in hand. She's just saying I disagree. But again, no foundation to actually say that she has the ability to verify when she's writing this declaration.
And if I can answer, Your Honor, she's the one who called 911 or called the police. It wasn't 911 in that case, but she's the one who called, so she should know which date she called on. So that's her personal knowledge of what she saw, did, said, and on the date she did it.
Well, I'll go ahead and allow it in the sense of I have a CAD report, so that by itself speaks for itself.
Next one is page 5 at paragraph, as for paragraph 20. So paragraph 20, line 11, So claims that my client is paddling the child and continues to do so, again, not in his home, no foundation.
Swinkles?
Yes, Your Honor. My client supplied a text message where the father is actually talking about paddling the child, and then Ms. Baldwin also submitted the text message from my client about paddling the child. So I believe that they both use corporate punishment or have used corporate punishment in their house. My client's alleging that she spoke to the father. That's where the foundation comes from. Testimony. Mr. is a party to the case and can easily deny that. That would be the foundation.
So the text messages that my client provides are the mother discussing her paddling the child because the child essentially won't do what the boyfriend wants or won't apologize to her boyfriend. So those are the text messages that we submit. I don't believe that the text messages that mother submits indicate that my client is currently paddling the child, which is the specific statement I'm discussing. And hey, Mr. has said, and there's no indications of that. These are people who have restraining orders. These are people that obviously are not communicating freely. So this idea that, oh, well, he told me, I think that A, it's not in the declaration, and B, it's very not likely.
So I'm going to strike that unless she's there in the home. There's nothing to confirm, and paddling can be interpreted differently, meaning paddling can be simply spanking a child on the bottom, and sometimes it can be while using a paddle. So it's a term of art, or not a term of art, but a term that can be read different ways.
And then same page at paragraph 21. So really the vast majority of paragraph 21 is hearsay. Child tells me that they're saying all of these things. So this is just pure child hearsay. But my client would absolutely deny that these statements are being made. But again, mother's saying, oh, father's just saying these things. It's all just really rampant hearsay and child hearsay. That it's not appropriate.
Ms. Winkles?
And I don't have the exact paragraph in front of me. Is there a way, can Ms. Baldwin read it?
Paragraph 21.
I have the wrong thing up again. My apologies. Can you read that first line of that?
I am increasingly concerned.
Paragraph 21. Which line was that? I'm sorry.
Line 14, 15.
And Your Honor can strike that. I think the pictures of the child and the injuries that were happening in Dad's house are enough. I can argue that without needing to argue anything the child said.
And that'll be stricken.
And then at paragraph 22, it starts with that same statement, child's wetting the bed in father's home. It's the same argument. She's not there.
And I believe Your Honor already ruled on that.
Yeah, I've already ruled.
So with that, I'm ready to proceed to argument when you're ready, Your Honor.
Okay, let's go ahead.
So in this case, obviously there's a lot of information on both sides, but I think what's frankly should be most compelling is there's one truly neutral witness, and that's the child's teacher. And I often say that children's educational lives are a good barometer for how a child is doing. When children are doing, especially young children, when young children are doing well in school, it generally means that things are going well at home because they're able to sit down, they're able to focus, they're able to get through their school day and do well. As a barometer. And so in this case, child's teacher reports that child is thriving. Child is thriving on the consistency that he now has in father's household and that he's doing amazing. This is the teacher's report. And that changing his schedule now would likely throw him off, and that she hopes that doesn't happen to him. And so that's the neutral observer that sees that child Monday through Friday, 8:30 to 3:30, every day. And so that is the person that I think sort of best tells the story about what this child needs and what's best for this child. And it's very telling what the mother's reaction to this brief report. This report does not slam mother. It doesn't say mother's horrible or some awful monster. But what is mother's reaction? Mother's reaction is not rational. She then goes and files a formal report trying to get the teacher in trouble for this email, and is proud of it. She's proud that she's gotten the teacher in trouble. And she says that in her declaration. She says, look at this. I made this report. I sent these emails and I said how dastardly this was that this teacher advocated for this young child. And that in and of itself tells you a lot. She has now tried to blockade and effectively, to some degree, has blockaded that witness from the future. It's likely that now, because you can see even the emails that they submitted, which are hearsay, but nonetheless, I let them in because I think that they're important for the court to see. It's now going to require us to subpoena that teacher and the school district to be able to get those records. We're probably going to have to depose the teacher instead of just talk to the teacher to be able to get that information because of how aggressive mother is to a simple email like this. And that is the inherent things that we're talking about in this case is mother's behavior and how it impacts this child. When we look at the mental health records that are submitted in this case, my client argues that he was not allowed to provide input regarding the domestic violence relationship, that if that was specifically like, nope, we're not going to take that information from you. And nowhere in the report does it indicate that that information was taken from him and considered. This is a 5-year domestic violence relationship. That is significant to your mental health. But even so, that whole piece of somebody's mental health being set aside entirely, we still have findings that are very concerning. The findings here are that there is a dysfunction in role performance. The report itself says dysfunction in role performance. Yes. Risk of deterioration. Yes. So this, in and of itself, we have this mental health report that does not say she is okay, and in fact says she is not okay and needs treatment. And then you turn and look at the treatment records. The treatment records that they submit, sort of saying, hey, look, everything's fine. Delve a little closer. If you look closer to those records, record after record after record says no progress, that she in fact isn't making progress. She isn't resolving the dysfunction. She isn't improving on the risk of deterioration. And I would argue she's getting worse. And that you see that in the balance of the rest of the case. And it's notable that we essentially say, hey, she's not going, she stopped. And I think she had. So when you look at her last appointment in this string is March 4th. We then filed April 4th. It had been an entire month with no appointments that she had had, no mental health appointments, which doesn't make a lot of sense if you're continuing treatment. After we filed, she then runs out and gets an appointment and says, oh, I'm still going. Look, I'm still going. But it's only days after she receives our declaration. So she's trying to repair that, but that only comes as a result of the litigation, not as a result of her genuine desire to work on her mental health issues and acknowledge that she has them. Again, so we see more than a month of gap in her treatment records. That is a concern. And when we see no progress, that is a concern. And when we see dysfunction, that is a concern. And these concerns laid on top of the other evidence presents a substantial risk to this child. When I talk about dysfunction, we see 20 911 calls. We dispute the dates. They don't dispute the calls happen. They don't dispute that it's call after call after call for things that are not emergencies, frankly. Things that are, and the claim is they're baiting me into violating. It doesn't even make sense. My client doesn't call 911. They're never trying to get her in trouble for violating. They're never in this position where they're claiming that, some kind of exchange, every time that she's kind of making these claims in 911, they're not panned out anywhere in this case file. Again, that leans toward the dysfunction and the deterioration, that this is somebody who is not getting better, not making progress. Similarly, her declaration goes on to talk about, this harassment, these lies, but doesn't give any examples of how my client is harassing her, other than just going to court and saying, hey, here's what's happening and here's what's not happening. And when he talks about, oh, he lied, I'm like, well, my client has documentation from the physician's office about their policies, has a formal letter that Kaiser issued saying, hey, this is what we told you. And she can't see that for what it is. It's lies. Folks like that, again, we talk about that being dysfunction. It's important to note that that dysfunction in and of itself leads to behavior. And really the behavior is the problem. And it's the behavior that led to the protection orders that are in this case. The allegations of those protection orders have been consistent. They haven't varied for more than a year. The stories have never really changed regarding those. And I would argue that her behaviors have not changed either. And notably, when you look at that mental health treatment progress, it is also unchanged. She has not made progress. Her behavior has not changed. And that's noted in her own mental health records. As a result of that, the protection orders had to be expanded and also extended. Again, because she's not making progress, She's not in a position where she's acknowledging her own issues. This is, I'll check the box and go to mental health, but I'm not actually acknowledging I have issues. There's really zero insight into her own behavior and zero acknowledgement. The domestic violence here is critical. When you look at the guardian ad litem report, she talks about the domestic violence for only a few lines, and that is troubling. And here's why. This is very much at issue in this case. This was a 5-year relationship with this person. And sometimes when you get a little bit deeper into a case, and some of the declarations have gotten buried by other declarations, what Mrs. is trying to do is act like all the declarations in the file just haven't happened, and we're just going to ignore them and just say, oh, well, it just never happened, so I'm just going to sweep it under the rug. But there is significant evidence of domestic violence. We have 911 calls about the boyfriend. We have her own text messages. We have the text messages between her and boyfriend. And that's part of the court file. The text messages between Lacey and her boyfriend, and I'll read it. It says, "You've gotten in my face multiple times before. You scare the F out of me and I don't trust you. I've told you that multiple times." That's not a text message of a relationship that doesn't involve domestic violence. These are people who are getting in each other's faces, yelling, screaming. Similarly, there seems to be just a flat denial, or I'm just going to put on blinders and ignore the declaration of Caitlin Slagle. This was filed December 5th, 2023. And I'll read a paragraph because I think it's really critical. This is the boyfriend's sister. She says, "I've known all these parties for years and years. I has relationships with all of them," and states how she's worried that even writing this is going to hurt some of those relationships. So she sort of acknowledges telling the truth sometimes is realistically injures some of your relationships with folks. But she says, "Lacey and Michael's relationship is nothing but chaos. Seeing the fights break out between them, the obsession, the insecurities, and the threats was and is eye-opening. I have personally witnessed this. Within the last year, I have heard Michael tell Lacey to go kill herself while he was in a drunken rage. Then he drove off and was out of communication for days. Lacey is stuck with him despite all the threats made to her, about her, and even Brody. Michael has threatened to leave her and take all her things. He has threatened to leave her and Brody homeless. He threatens to kill her dog, Rudy. This is not safe behavior. These are threats which are indicative of domestic violence and should be taken seriously, not just shrugged off by Lacey." And it goes on. And it talks about additional incidents that have happened between these two people. And so when you have all of this evidence of this long-term domestic violence relationship, it creates a significant concern. And you put that together with photos of marks and burns that happened during the mother's time on the child. They're without valid explanation. Mother says, "Oh, it was a jump rope." I'm like, that doesn't make any sense. And we often talk about, does that injury make sense? Is that a child, is it their shins? Or how does a jump rope cause a burn to your neck and bruising to your back? That doesn't make sense. She admits to paddling the child in a text message. She submits photos of injuries that my client's like, those are actually my photos that I submitted earlier in the case. And she's just recycling them now and claiming that they're hers. And then similarly, she submits photos where my client's like, you can look at the date and timestamp. Those are occurring during her time. It's not occurring right after the exchange. She's like, this is the end of her time. This is not the beginning of her time where she's kind of getting the kid saying, hey, what happened? This is right before we're going to switch back. And she's sending these texts. She's sending these, or those photos are what happened then. It's important to remember that domestic violence is a cycle, and without treatment, that cycle repeats. We all know that. And in this case, Mrs. is in full denial. Her declaration, the last one submitted, says there was no domestic violence whatsoever. She denies it entirely, despite lots of evidence to the contrary. And again, essentially, we have this statement of, well, he's gone, so just ignore it, just wipe it away. But domestic violence puts children at significant and exponential risk. And I think it's notable. Domestic violence is a 191 factor that we have to consider. What other 191 factor would we treat this way? If someone was using methamphetamine and they said, trust me, I stopped using and I won't use it again, would that be the end of the story? Or would we say you need evaluation, you need treatment, you need help? If someone said, I'm schizophrenic, but hey, I'm promised that I'm cured, would the court say no need for medication, no need for treatment? If my client was the one accused of being the domestic violence abuser, the court would, or absolutely, there would be an evaluation, there would be treatment, there would be limited time. But why here, where mother simply says, well, he's gone, don't worry about it, ignore that it happened, move on. Act like this is just something to kind of wipe under, sweep under the rug. And that's where, there's no follow-up, there's no concern. And that's where we do have to talk about inherent bias, where it's important to note that we have one party is male and one is female, and we have traditional gender roles. And so that absolutely can play a part in, well, if Mr. was accused of domestic violence, there'd be all of these things that we would be very significant about. But if Mrs. is the one that is exposing child to domestic violence, well, she says it's done. So we're just going to ignore that. Again, 5 years is a long time to live in a domestic violence abusive relationship. And it's a long time for that child. That is a lot of abuse that child's witnessed. And to have that child be on that cycle and just ignore it is not appropriate. That is something we absolutely have to consider. It's notable when we think about the father's household, there are no concerns, really none whatsoever. And per the teacher, child's doing amazing. Child's doing great with father's consistency. Child's slowly returning to a healthy weight and a healthy BMI. My clients noted that progress. My client is making sure he's meeting all of the appropriate appointments, all the appropriate milestones. There's literally like no concerns when it comes to his household. When we look at Mrs., again, we have the verified dysfunction and risk of deterioration. We have protection orders. We have many calls to 911. We have the protection orders. We have the domestic violence with her denials. We have the photos indicating physical issues with the child as far as unexplained injuries, her admitting to paddling the child, locking the child in his room. There are very significant concerns that need to be fully investigated. We're here on just an interim report. We need a full investigation, and for that investigation to consider all the evidence, not simply child's self-report, not each party's self-report, but to meet with each of the witnesses and to meet with all of the collateral witnesses in this matter. So what should the court do? In this case, my proposal is the court maintain the current parenting plan. The court should send us to the Wednesday docket for a trial date. Trial dates are always a little ways out. We should get one on the books now. Likely, this is a case that needs to go to trial. There's obviously a lot of information on both sides that needs to be presented. The parties do agree that the child needs counseling, and my client is absolutely in agreement with that. The parties should select an agreed counselor if they cannot. That's not associated with either party or either party's, medical office or counselor. I always think that that's appropriate. And if the parties cannot agree, then the court can select. And we should do that within the next 2 weeks. I think there shouldn't be a delay or any further delay on that. I think that's a reasonable outcome for where we are. And again, some very significant concerns that deserve to be fully investigated in this case.
Thank you. Ms. Winkles?
Yes, Your Honor. There's an overall theme in this case, and that's one of a problem with credibility. Now, my client, when she went to the DVPO hearings and those hearings, she didn't really present a lot of evidence. What she was hoping is to maintain the relationship and essentially wait it out. But we really need to look at that because I think credibility here is the most important thing. If you'll notice from the text messages that my client submits, her and Brooke Adams, and I'm going to call Brooke Adams the stepmother, but the parties aren't married. They're not married. Brooke Adams stated a number of things, and so did Dad, that my client essentially went out of her way to stalk them and do all of these things. And they submitted some dates. My client, what she submitted is showing that these parties were very good friends. And my client, Dad says, she told me that the new child that they had should have been hers and mine together. But what you'll notice is that my client was informed immediately after the child was born, and my client sent Mom flowers. Dad says those flowers were to me. So Mom submits the receipt to the court showing that Mom ordered the flowers to be sent directly to the hospital room of Brooke Adams, congratulating her on having this beautiful baby. That time that she had the child in the DVPO, and in this case, Dad says that at that time she was stalking and she was coming to the house unwarranted and unwanted. That was a week after my client sent these flowers. Then we look at the next thing. They say that, again, she's stalking them and she doesn't want them, they don't want her around. Well, that goes contrary to the fact that Dad and Brooke Adams, their child, they let my client take their child alone. So obviously we have no concerns in 2023 of my client essentially doing anything to the child or doing anything to anybody because they send their own child, 2022, they send their own child to the parade with my client. And you'll see the text messages there. They say, where do we pick them up? Where should we drop them off? My client is alone with a child that's not hers. That shows this really intimate family relationship. You then see text from Brooke Adams herself saying, I'm so glad that we're friends. I'm so glad that we can do this and co-parent. They then invite her kayaking. They invite her camping. They invite her to the house. What happens, though, is you'll see that my client got upset. She got upset because Brooke made a statement about being able to get this child to do something that my client couldn't. My client overreacted and ghosted Brooke. That is when this all started. That was November 8th of 2022. Now, you'll see from all their pleadings that they go back in time well before that, claiming that as of October 2021, that my client was stalking them and harassing them and doing all these terrible things. That's really not the case. They claim that my client essentially threatened to kill them in May of 2022, but yet they invite her to go kayaking in June of 2022. She says, "Congrats, mama." At that time, according to their declaration, my client is stalking them at their house. We then see that they're claiming that they both were sleeping with firearms, but you'll then see the next text message saying, "We would love to have you, can you go camping?" And them saying no. Now, my client was with Michael Slagle this time. You'll notice the August 2023 text that was submitted from dad to my client, essentially saying that there were no issues, that they didn't think so. In November of 2022, did Michael Slagle and my client have a bust up? Did he get in her face and yell? Maybe. That occasionally happens in relationships. It doesn't say if the child was there or not. All it says is, "You got in my face, you scared me, stop." That doesn't show any domestic violence. Now, what they've tried to do is strike any of these pleadings, any of this hearsay, based on a lack of foundation for my client's allegations of bedwetting and so forth. But what they attempt to do here is claim domestic violence when they're not in the house. They claim that there was a 911 call, and there was one 911 call concerning Michael Slagle, one, in a 5-year relationship, that said he broke a Christmas ornament. And he did. And she broke up with him. She left him and he was gone. That shows a clear indication that my client is not willing to put up with anything. She mentioned back in November of 2022, "You got in my face, I didn't like it." Considering when he broke an ornament, she broke up with him and kicked him out of the house and kicked him off the lease. You'll see that from the landlord, not a party to this case. You'll see the lease, he's out. But what you see is that obviously she spoke to him and he stopped. Because we know he stopped, because the next time he broke an ornament, she was done. He's moved out, he's gone. Yet they make this claim that he's still there. And who do they use to kind of reaffirm this? They use Mr. Slagle's sister. And my client claims neither Mr. Slagle nor my client have had anything to do with the sister for over 6 years. My client herself has never seen him in the last 2 years. This is the same sister that wrote a declaration claiming that she saw them somewhere, yet my client was at work and submits her work records showing that she couldn't have been there. There is a massive credibility issue here. First, we have dad making all these claims. Now, my client submitted no proof in the DVPO, so a DVPO was granted, or an anti-harassment order was granted. But what she's done in this case is actually submit the proof. And you can clearly see that on every day they state my client is stalking them. A couple of days later, they ask her to come over. They ask her to hang out. They say how great of friends they are. There's pictures of her with their children alone. This is clearly the case of a stepmother who got mad at my client's reaction and decided to get rid of my client. Now, why did my client call? Not 911. You can see that from the CAD reports. Why did my client call the police? She called the police because of this credibility issue. They had already made all these claims that were clearly not true. My client was incredibly frightened that she was going to get arrested or have something used against her when it wasn't the case. We can see this in some of those CAD reports saying, "Hey, I'm afraid that I'm going here and I'm afraid something's going to happen. What do I do?" And that's all the CAD reports are, is "I'm going here. I want to let you know." And the cops say, "That's good. Keep telling us." So she does that. Now, Brooke calls 911 twice. First, she claimed that my client took, or essentially was at a game harassing her. My client wasn't even there. We submit her work records. Then Brooke called 911 when my client wanted to take the child to a monster truck show. We see these things. We see this baiting. We see this attempt to get rid of mother. We can also see this coercive power of Mr. They gave him the medical decision making, and you can see his texts that state, "Well, I will decide. I will decide." And then they attempt to rely on this statement from Kaiser. Well, here's the deal. He told this court in ex parte, which again is not really what ex parte is for at all. It's for an emergency. Told this court in ex parte that only one parent was allowed. That wasn't true. Absolutely not true. Miss Turnbull does an investigation, finds out that's not true. Another credibility issue of dad. So what does he do? He reports to Kaiser, but he gives no name. They tell the person's name of who spoke to my client, yet he's self-reporting. Of course, Kaiser is just going to believe this. Yet another credibility issue. So what do they attempt to do? They attempt to rely on the teacher. This is the very same teacher that wrote a statement for the DVPO claiming my client had no reason to be at the school at the time. Yet my client submits that email to this court in this hearing. She didn't do it in the last one, showing that the teacher specifically asked my client to attend. And this is the same teacher that Mr. now wants us to rely on. The same teacher that's mentor, the direct supervisor above her, is the aunt of Brooke Adams. And they're going to say, well, the names are the same. No, that is the aunt of Brooke Adams. The fact is that everything in this is blown up, a credibility issue. We look at the supposed injuries of the child. The child goes to daycare, rubs a rope on his neck like this, goes to my client's or goes to dad's house. Dad takes a picture of it and you'll see the text. Dad said, "What is this?" Mom says, "Rubbing a rope on his neck at daycare." Dad then sends a text later saying, "Oh, we're so sorry. It's all right. It must have been the hot water of the shower that made it appear so much worse." It wasn't bruising. It was clearly an irritation. Hot water exacerbates. Hot water vasodilates, causes blood to rush to certain areas. As soon as the kid dried off, as soon as the temperature went down, kid was fine. I want to remind the court that this is the same dad's house where the kid has had black eyes, bruising all over his body, got into an accident and had to be air flighted because he wasn't wearing a helmet and dad wasn't watching him. These are the issues that are at dad's house. Dad is the one who has always used corporal punishment. Mom paddled a little smack on the rear end one time. There have been no allegations prior to today about any domestic violence occurring at mom's house. What you're seeing is an attempt, a frantic attempt to throw spaghetti at the wall because all of dad's things have been fabrications. And we know this because we have text messages on every single one that backs it up. Dad says A happened. We then look at the text message. Dad lied. We have B happen. Look at the text message. Dad lied. And this is the thing is my client never used these texts. Most likely they didn't believe they existed. And so when my client now brings them up, oh no, we have a problem. Dad's been lying for the last 2 years. What do we do? Let's say that she's in a 5-year domestic violence relationship. Where's the evidence of that? We have a sister who knows absolutely nothing to Mr. Slagle. And we have Mr. Slagle saying some really horrible things after they broke up, which is why my client broke up with him. You can clearly see that from the lease. Now, we talk about whether or not my client has had mental health issues. So essentially, we're asking the court to wonder why a woman who's been an amazing mother to this child and has had 50-50 custody of this child throughout his life. His grades were absolutely perfect until essentially November 8th of 2022, which is when dad's campaign against mom began. So we're wondering why there is an issue with dad or issue with child's grades. Well, child's grades are absolutely fine until November of 2022. Then we see a problem at school. And now apparently his grades are fine again. Let's think what happened there. That's when dad's campaign against mom started. Dad's disparagement against mom started. The child's of course doing all right now, because there's no reason to disparage mom because dad won. Dad doesn't have to, mom has almost no visitation. There's no reason for this campaign at the moment. So child is of course doing well. What child would do well is if dad stopped lying to the court, stopped fabricating, and stopped attempting to get mother in trouble for things that are easily proved and that mom's not doing. The fact is mom had an evaluation. And what they're claiming is we see no change in a month. If mental health professionals were able to help somebody in 1 month, this world would be a much different place. But how can mom get better when the fabrications are continuing? Mom has had over 50-50 custody for this child's entire life. That's pulled away for things mom knows are false. Mom knows dad is lying. Mom knows dad has made statements that are clearly not truth, and she has proof of it. What mother wouldn't have a mental health problem from that? She's essentially had her visitation cut by more than 75% for something that isn't true. Dad has made it very clear he does not want mom in this child's life. And the GAL is here today, and I think the GAL would concur with that. Dad wants nothing to do with mom being in this child's life. Mom is the opposite. Mom wants dad to be involved and has tried to facilitate that the entire time. So again, we're asking to rely on the teacher's declaration, a teacher that, contrary to district policy, wrote a declaration in 2 cases. The fact is the teacher did that because this is a very tight community in Castle Rock. It's very small. Her mentor is already the aunt of Brooke. The only reason she would put her teaching up for that is obviously for a good friend or a family member. We've seen dad have no problems with mom. We've seen them get along really great. There's no stalking. There's no mental health. Now, dad, what does he do when he finds out, when he knows that everybody knows he's lying? He starts bashing the people. And we have to really think about who he's bashing here, ignoring mom from this situation. Who is he bashing here? Who is dad lashing out at? The guardian ad litem is number one. First, he takes a Scrivener's error of an accidental date put in, and he says, she didn't do a report. This is Amy Turnbull we're talking about. This isn't some GAL that this court doesn't know. This is a GAL that's in a significant amount of cases that has clearly stated no issues in mom or dad's house. Then we look at the evaluator. Then they say, this is a social worker. She's not able to do this evaluation of my client. Well, actually, the law says she can. And she has more education than a simple therapist. She's a licensed clinical social worker who is able to do evaluations. The WAC actually says that in it. So then dad says, I didn't have any collateral time whatsoever. And what do we have from the therapist or from the evaluator? the dates and times of speaking to dad, what dad said. So obviously, once again, another lie of dad. And one wonders if dad has a mental health problem because he continually lies to this court over and over again about, she said she wanted the baby to be mine. The flowers were sent to me. She stalked us at her house. We see a picture of her waiting here. Yet the text messages are between them saying, hey, come on over. Do you want to do this? Do you want to make cookies? Do you want to do this? All of this stuff is lies. And yet dad keeps doing it. Then he says she can't come to the court. She can't come to the hospital. Well, she clearly can't. I never spoke to that woman. He clearly did. Every single thing that is being said by dad, which is really shocking because they're very easily disproved, as you'll see from my client's evidence that is very pointed, is a lie. Then they say Michael Slagle's still there. Michael Slagle's moved out. There's a lease that shows that. There's an empty room in the picture that shows that. They really are grasping at straws. Your Honor stated in our last hearing that if there were no concerns on that GAL report, that you would be looking back at the 50-50 plan that these parties have had in place for over 6 years. The GAL has no concerns. Now, the school is a problem. My client understands the child is in school for another month and a half. What my client's proposing is that we slowly expand the time until the child's out of school. And then starting in summer, we go back to the 50-50 plan it was. The fact is that there have been enough fabrications. My client's literally lost visitation over lies that text messages show that that's what they are. He continually lies to this court. There's no neglect. There's no harm in my client's house. And when they show you these bruises on the kid, I ask Your Honor to look at the date because these were taken on day one of mom's visitation, which means they happened at dad's house because you can clearly see the bruises losing color over time. We have a series of photos. Every injury that happened, and we're not saying dad's abusing this kid. This is a little boy who could fall off a bike, who could, jump off a ledge. Little boys do all kinds of things and get injured everywhere. They get injured at daycare. They get injured at, they're little stuntmen in a way. But what we are saying is dad's abusive use of conflict, his attempt to remove mom from the life of this child is appalling, especially when this started over mom overreacting to Miss Adams. And it could have been ended there. But instead, dad and stepmom decided no more for Miss Klopp. She's out of the picture. We're going to get her out of the picture and started a campaign essentially against her and have been successful until now. We probably could have ended this had she submitted all this stuff back when she first had it, but she didn't. She has submitted it to Your Honor now. We ask you to review the evidence in full because this is a travesty. It's essentially a travesty of justice considering these are all things that can be proven. We'd ask Your Honor to go to this expanded to 50-50 time. And I'd also ask Your Honor to not allow any rebuttal because this is not Mr. Klopp's motion. This is a GAL review only. Miss Baldwin's already spoken. I've now spoken. I'd ask for you to speak to the GAL, but this is not nobody here is the moving party, and it would not make sense nor fairness to allow either of us a rebuttal. So I'd ask that you speak to the GAL. Thank you.
Do you want to hear from Ms. Turnbull?
Thank you. I have spoken with the counselor. I've reviewed the mental health report of Ms. Klopp. I've spoken with the regional director of Kaiser who manages the sleep study. This was all in my report, and at no point did anybody have concerns with Ms. Klopp. The parties are aware there was a recent CPS report by one of the school counselor, and I spoke with a CPS social worker who was in Ms. Klopp's home last week. She also did not have any concerns regarding Ms. Klopp or her home. I have not, all of the third parties that I have had contact with have not had any concerns. I did have concerns that Mr. Klopp did manipulate some of the information. The sleep study, sent me an email afterward that said he did have conflicting information. But when I spoke with the regional director, she did report to me that she contacted both Mr. Klopp and Ms. Klopp and informed them that essentially two adults could be in the sleep study, that they would have possibly a second room that they could use. They could, have one person on the floor. They could take turns. That they would accommodate this, that two parents could be there, that essentially the one adult had to be present. You could not just leave your child. That doesn't mean that two people couldn't be there. And I asked her if in the records it indicated anybody had contact with either parent after her conversation, and she said that they had not. That there was no record of any contact with the parents regarding this issue after she had called them. So that gives me cause for concern that that information, even if it had been conflicting before, her call was to clarify. And so that's where that piece of information is. I do have some concerns about Ms. Klopp's previous relationship, and I do think that some education and counseling regarding domestic violence is appropriate. I do think she was the victim in that relationship, not the perpetrator. And so having a domestic violence evaluation would not be helpful necessarily in that sense because she was the victim. I think that it would be a counseling recommendation. So I think that's where we need to go on that front. Let's see. I'm trying to think of any other questions that you may have. In terms of recommendations for moving forward with the parenting plan right now, I do think Brody is really significantly in the middle of his parents' conflict. And that is my biggest concern right now. When I spoke with him, he essentially said he tells his mom what mom wants to hear. He tells his dad what he wants to hear, and he doesn't really know what he wants. But I think that by giving those answers to each parent, that is just stoking the fire of the conflict between both parents. And they really need to stop asking him what he wants and, asking about what's happening in the other home. And he needs to be in counseling. And I have expressed this to both attorneys that it's critical. And the CPS agent also is going to be recommending that. So he's sad. He's just a sad kid right now. And he misses his mom. So whether you decide to go back to the 50-50 or you want to keep more stability throughout the school year, I do think some more time with mom would be appropriate.
So one of my questions has to do with long-term plan for a final report. What are you looking at? What are you thinking you'll need?
I would say another 4 to 6 weeks.
Okay. All right. Thank you. So in regard to the idea of rebuttal, when new information is brought up, it's not a matter of whose motion. It's more a matter of one gets to hear all the argument of one and then be able to respond and add additional, but that doesn't give the other the ability to respond to the information that's brought up by the others. So with that, Ms. Baldwin, if you can address just any new information.
So a couple things. Again, it's concerning that we have records from the sleep study that say one parent to attend. We have a letter from Kaiser themselves that says, yeah, we told you it was one parent directly. This is their official in writing statement that says, yep, we told dad it was one parent. We probably told mom something else. That's on us. But it's couched in my client being malicious when he wasn't. And it's notable that this is a sleep study. Mother's request was, despite the difficulties between these two people, she wanted to come and sleep on the floor next to my client during the sleep study, which it would absolutely have disrupted the efficacy of that sleep study. Her interest was herself. She was most important in that situation. Not, this is not a surgery. This is just a sleep study. Child is most important. This is just getting information like a blood test. They don't both need to be there for a blood draw. So again, even Kaiser says, this is on us. We told you different information. And all the documentation supports that my client in no way did this maliciously. And it's frankly logical that both parents were not there. As far as the domestic violence, the claim that domestic violence has not been on the plate from day one is contradicted by the records. And again, I quoted records from back in December. So that's absolutely been on the table since day one and very clear. We have never said that Mrs. was the perpetrator, but that instead she is stuck in a cycle of violence and that absent treatment and acknowledgement that she needs treatment. She's in a pure denial state right now. That absent that acknowledgement, that the cycle will repeat, and that cycle puts the child in danger. Similarly, the statement that my client lied and said he's never had collateral input. No, his statement to the court specifically was, I was not allowed to give collateral input on the domestic violence issue. That was the issue he was not allowed to provide any input on. So he says, like, they would take information from me, but on this, they just said, nope, you're not allowed on that issue. So that's specifically what his declaration states. So not that he doesn't have any input, but very specifically. And again, that's one of the main issues in her mental health. The fact that she's receiving mental health treatment is good. That has not been on board just recently. She's had mental health treatment since January, and there still is in a position of no progress. As far as the claim that the protection order was not defended against, that's also not accurate. Ms. Klopp in this case filed her own protection order, which was denied. So she filed sort of a collateral defensive protection order, and that is how she responded. So to say she didn't respond into that file, she just created a different file that was heard at the same time. So again, that's sort of a bit, or is directly misleading. So in this case, what is in the best interest of this child? Stability is in the best interest of this child. The child getting into counseling, the investigation being fully fleshed out. And it is concerning that we have reports to CPS that are coming from not either party. These are coming from third parties who are then saying, hey, child's making some concerning statements, and investigations are occurring as a result of that. So again, that leads to their concerns there, but those concerns are underpinned with evidence. And so we have to do what's right for the child. Child is priority. And so again, I think that my suggestion is a good one, that we maintain the current plan and set us to the trial setting calendar to get a trial date. I think that this case is likely one that will proceed to trial.
Brief response, Your Honor. Very brief. The CPS, we have no indication that CPS was called on mom. And in fact, I believe one of the CPS calls was against dad's house. Second, the DVPO that my client issued was actually dropped. It wasn't denied. Finally, this child has stated to the GAL that he's sad, that he misses mom. There is no reason why it would not be in the child's best interest to increase visitation with mom. What dad is asking you to do is, let's let this child continue to be depressed until we set for trial. There's no reason. There have been no concerns by mom, by anybody. Should mom go to counseling for being a victim of DVP, domestic violence, if she is? Absolutely. My client has no problem doing that. But there's no man in my client's house. There's no boyfriend. There's no immediate threat to the child because there's nobody in my client's life. There's just my client and the child. So my client would ask that we do what the child wants and needs. We help the child. We expand mom's visitation. And come the date school gets out, we go back to a 50-50 plan. Then we wait for the trial, which most likely will be at the very end of the year, given the trial schedule. And hopefully that summer with mom and summer with dad, if these parties can just stop talking to the child about anything, and we can put that in the order. Neither party speaks to the child in any negative way about the other parent. Either party asks the child about anything. Neither party does this. And the child's in counseling at that point in time. So the child can say if somebody is violating this easily and has this third party to talk to. But there's no reason why this child shouldn't see mom more. The only person that has a concern with mom is the person who is fabricated with evidence that clearly proves that, not just the Kaiser, but a whole host of things, including dates and times. So we'd ask for expanded visitation until June 14th. And then come June 14th, we go back to a 50-50 plan where there's clear measures in place that allow neither party to talk to the child about the other house. Let's just pretend the other parent doesn't exist for the child. Enroll child in counseling immediately. And the GAL can then review and drop in as needed to both parties' home. That makes sense. What doesn't make sense is to punish mom for a relationship that no longer exists and to punish child. That's really what we're doing by leaving child away from mom. This is a depressed kid. That's not fair to him. And when school's out, we have no educational issues at that point. School's out. So we'd ask for the expanded visitation as far as Your Honor sees for the next month and a half, and then go to it's not even a month and a half now. And then go to a 50-50 plan and then set the GAL report, let's say in July, come back and we can go from there. Set a trial in the meantime, but let's be honest, the trial's not going to be until November or December. Thank you.
So first question I have is, when is school out?
Usually June 10th to 15th.
I think it's the 14th this year.
Okay. All right. So first, I'm going to talk to the parents. One of the things that makes me very angry and upset is when parents decide that they are going to involve their child or children in the middle of a custody matter. Those children or child, in this case, has a right to love both parents and not be torn apart because the parents are going at each other. I expect you to act as adults, let the child be a child, and do not involve this child in the middle of this legal action. You're not to talk about it. You are not to talk about what goes on at the other person's house. You are not to talk about and ask that child anything about anything related to this case. That child wants to love each of you. So stop putting the child in the middle. It scars them. It scars them for the rest of their lives. So stop. In regard to what's going to happen from here, the court has reviewed the interim report as well as the pleadings associated with it. The court understands it was an interim report, but what the court also sees is a lot of pointing fingers and blaming everybody else but taking responsibility, and that's for both parents. That always makes it difficult, so credibility becomes a big part of this. And obviously when all I see is a picture of somebody sitting on Zoom, that can be very difficult. And that's where the court does rely on the guardian ad litem to make that investigation and give at least some sense of where that is. And the court has some issues with credibility on both sides. Again, it seems to be a who's going to win rather than what's best for our child. So the court is concerned with the many issues that have been raised on both sides. And the interim report simply is not going to get to the bottom of those issues because there are a number of them. So based on the files and record and figuring out what's in the best interest of this child at this time. And this is not a decision to be taken in the sense of a final decision. And this is a temporary order. This is a process that needs to occur. And so at this time, in regard to what the court is going to do, is going to change the current schedule just slightly, because what the court does not want to do is upset this child any more than the court needs to. So what the court is going to do at this time, and I apologize, I think I was looking at the parenting plan when I did this, came up with this, but the mother is going to be having the child the first, third, and fifth Thursday from the time school is released, or 9 a.m. if no school, to Sunday at 5 p.m. That is commencing this Thursday. And then the mother is also going to have the child, I believe she's having the child on Wednesdays. Ms. Winkles, is that correct?
Yes, that's correct, Your Honor.
Oh, no, that's not correct.
I'm sorry. Oh, what's correct?
There's no midweek in this.
Oh, yeah, my apologies.
Okay, so there is no midweek. Okay,
Correct.
So the mother is going to have a midweek and just basically the same time from the time school is released until 8 p.m. And if no school, then at 9 a.m. That would be on Wednesdays. I thought about making it Thursday, so Thursday was consistent, but that creates other problems, I think, down the road. So I made it Wednesday. I don't know, counsel, Wednesday or Thursday, I'm good either way.
I think Wednesday is fine, but I would make the suggestion, because it avoids contact between the parties, instead of Thursday to Sunday, if you do Friday to Monday, mom picks up from school, she drops off at school, the parties don't have any contact.
Yeah, does that work for you, Ms. Winkles?
It does, and I can also suggest Tuesday instead of the Wednesday. So the way the schools work is they all have a shorter day on Wednesday. That way the Tuesday, I guess Wednesday after school is fine. I was just thinking about, I think I got it wrong. My apologies. I was looking at a different schedule. I think the Wednesday is fine. I think they have a shorter day on Wednesday, and then turning at the 8 p.m. is fine. My apologies.
So it'll be Wednesday for the midweek, and then that's fine, Friday to Monday. That's fine. But if they don't have school on Monday, then it would go until 5 p.m. that day.
Okay.
So that changes that time just a bit. And if no school on that Friday, 9 a.m. If no school on Friday.
Very good.
All right, and then the mother shall not have the child around Mitchell Slagle. I think that's the name. And then the court adopts number 2 through 5 the recommendations of the guardian ad litem. And in regard to the counseling, I think it was Ms. Winkles, I can't remember who it was that suggested that if the parties can't agree that it comes back to court, I'm not sure which, it doesn't really matter, but see, the parties agree. I don't know, because Kaiser is the provider, if that somehow plays into who's available for that. Do you know, Ms. Winkles?
It does. Kaiser has their own in-house child counselor, Dr. Leah. I don't know if that's the child's doctor, but that's pretty much every child's doctor in this area. She would make a referral based on the recommendation, and we can actually send that directly to Kaiser, and they will refer the child to a child psychologist.
Okay. So essentially, I'll rely on that. That's who the child will go to. So it's covered by Kaiser, and then I understand that there's some counseling, the mental health counseling happening that needs to continue to happen. But what the court also wants is for mom to go to the domestic violence class at the shelter and file proof that that was done. Ms. Turnbull, were there any other evaluations or anything that you wanted?
Not at this time, no.
All right. So in regard to the summer time, the court is not ordering. I do want just the standard holiday schedule that needs to occur.
And that's already part of the plan.
Okay. Let's see. So I have counseling that. And then what I'm going to do is set this on for June 2nd, excuse me, June 4th for a final guardian ad litem report. I'm hoping Ms. Turnbull can have it done prior to that time.
Yes.
And then look at the summertime and what the schedule is going to be like from there.
The court, so council referenced maybe setting out into July because we won't have the child's counselor's input likely within the next 3 weeks. I didn't think that was a bad recommendation, is to allow for the child's counselor to have input.
And Your Honor, I'd ask for it to be in June before school gets out, because then we're using half of the summer where a child can be integrating back into mom's house, if that's going to be what the court decides. Otherwise, we're looking at less than a month to integrate the child, which will be difficult.
It'll be June 4th. That's when the guardian ad litem's report is supposed to be done. Hopefully we'll have at least some information from that counselor by that time. If not, we can address it at that point, but I do want to have something going before summer.
And then the guardian ad litem's recommendations included you're adopting 2 through 5. That includes my client taking a parenting class. He's already done that. So I just asked that we strike that because my client's already completed that and filed proof of that with the court.
Okay. Yeah, that can be stricken.
And
So
my client has taken a parenting class as well.
this investigator recommends Lacey Klopp does not introduce Brody to a new romantic interest for 9 months. Court's adopting that. We already talked number 3 about the counseling. Number 4, if that's been done, then that's fine. That can be stricken. And then 5, that the mother discuss signs of an abusive relationship and appropriate boundaries with her counselor, which is essentially already talked about as well.
Presentation in 2 weeks.
So in regard to presentation, I'll go ahead and add it to that May 7th.
Okay. All right. Thank you, Your Honor.
Okay. All right.
Thank you.
That concludes this docket.